Can assets be given away to qualify for Medicaid? An applicant generally cannot give away assets to become eligible for Medicaid. Such gifts constitute divestments that cause an ineligibility period. Specifically, the value of all divestments made within a look-back period are added together to determine a penalty period. A divestment is a gift of countable assets or income. The look-back period is a 60-month period prior to the date of the Medicaid application, and the penalty period is a number of days following the date of the Medicaid application during which the applicant is ineligible for Medicaid because of the divestment. The penalty period is determined by dividing the total of the divestments made during the look-back period by the average daily cost of a nursing home. The result is the number of days of the penalty period. For example, if the average daily cost of a nursing home is $300 and the applicant has $9,000 in divestments, the penalty period is 30 days. This is determined by dividing $9,000 by 300. Certain gifts are specifically excluded from the divestment rules, so they do not cause a penalty period. For example, gifts to a spouse or to a disabled child are not divestments. Can Medicaid take an applicant's home? Medicaid does not take an applicant's home, nor does the state require a home to be transferred for Medicaid eligibility. Instead, the state may place a Medicaid lien on an applicant's home to recoup Medicaid benefits expended on the applicant. A Medicaid lien entitles the state to a portion of the proceeds from the sale of the home. For example, if the applicant received $100,000 of Medicaid benefits, the lien on the home would equal $100,000. If the home was sold for $200,000, the state would receive $100,000 and the applicant or his heirs would receive the balance. A Medicaid lien cannot be placed upon an applicant's home if the applicant, his spouse, or his minor or disabled children reside in the home. How do I plan for Medicaid eligibility? Medicaid eligibility planning generally falls into one of two categories. The first category involves sheltering assets before long-term care is needed in order to protect the assets from a Medicaid spend-down. For example, a parent can shelter an asset by transferring it to an irrevocable trust or a child more than 5 years before a Medicaid application is filed. Gifts made more than 5 years before a Medicaid application do not cause a penalty period, regardless of the value of the gift. The second category involves sheltering assets when long-term care is immediately necessary because the applicant is in a nursing home. Substantial wealth can be preserved even after the applicant is in a nursing home. For instance, countable assets can be converted to exempt assets by making repairs to the applicant's home, prepaying funeral costs, or transferring assets to a qualified supplemental needs trust. Countable assets can also be converted to unavailable assets by listing real property for sale or exchanging liquid assets for a qualified annuity or promissory note. Through such techniques, Medicaid eligibility can be obtained without spending out all the assets on medical expenses. How can private insurance be used in Medicaid eligibility planning? Private life and long-term care insurance can be a valuable component of Medicaid eligibility planning. As previously discussed, insurance can be used to recoup funds expended during a Medicaid spend-down, and private long-term care insurance can be used to increase the Medicaid asset limit by the amount of the benefit paid under the policy. Long-term care insurance can also be used to pay for an applicant's care during a penalty period. For example, in Wisconsin, a long-term care policy providing for 3 years of coverage may provide funds to cover the cost of a penalty period for a $300,000 divestment.